We now move on to Senator McDowell is up next.
Thanks, Chairman. Welcome to our speakers today. There are a number of points that I just want to throw out. One is, are there any of the regulations that anybody who is critical of the entire package actually favours? Because the House of the Oireachtas are being given a job lot, adopt the whole thing or nothing. And I don't know about the legality of that and the constitutionality of that, since they are all separate options. But is there any of the NGOs who are opposed to the entire package content with any of the regulations and in favour of them?
Mr. Henderson, do you want to go first?
No, there's 9 regulations in total, yeah. 7 of which are being proposed. To put it simply, for every, we can point to parts of each regulation that could be positive, as colleagues have said from UNHCR and Mr. Leonard. But we feel that an analysis, bearing in mind that there's 1,300 pages of legislation here, and that analysis is ongoing, that an analysis of each leads us to conclude that there is more bad there than there is good. Yeah. So that's an attempt to answer your question.
Would you, I think the senators was asking, would you, if there was a pick and mix option available, is there something you would pick?
But as I understand it, it's each regulation would be proposed to the Dáil, not the total package.
A single resolution to exercise our opt-in for the whole lot.
Well, that.
But I mean, I don't know whether that's lawful constitutionally, but I mean, because it has to be, each measure has to be separately voted on, and that's another issue. But I'm just wondering, is there anything that the NGOs could say, well, say the Eurodac regulation has no particular problems or whatever?
Well, the one that would stand out would be the AMRR, the migration, the responsibility, the Asylum and Migration Management Regulation. You know, that the initial genesis of that, as I understand it, was an attempt to support southern member states, e.g. Italy and Greece, who were taking a disproportionate number of people seeking protection, and that it was an attempt to relieve them of responsibility. But that started with good intentions but became increasingly watered down to now we have a point where you can pay your way out of responsibility. And so that initial good intention has been lost to a certain extent. That is also coupled with an update of the existing Dublin regulation, and we would have concerns within some of the devices that have been established and added to that Dublin regulation. So that's the one I would say we would pick that could have begun with good intentions but has been gradually watered down, unfortunately.
Mm-hmm. Could I then ask, in relation to the border procedure, Senator Gallagher elicited from the Minister on the last occasion that, in her view, 80% of applications for international protection were from people who had come to Ireland from the United Kingdom, and that was based on the proposition that they seem to not have gone through migration controls at ports and airports. Does the border procedure apply, and maybe if anybody has a view on this, does it necessarily apply to somebody who arrives at Mount Street, having been here for a period of time? Do any of in other words, it seems to me that the border procedure seems to be tied to the notion that you're unlawfully present and you've been detected entering. But I have a big query as to whether the border procedures and all the accelerated time limits will apply to people who just, say, for instance, a student on a visa here who goes down to the IPO office and looks for refugee status. Does it apply to them at all?
I might be able to answer part of that. I think so for a student who is legally resident here, they might not be caught by part of the border procedure, but they may, if I understand this correctly, be caught by a separate aspect if they come from a country that has, we'll say, 20% or lower recognition rate. So you can be caught by one or multiple provisions of the border procedure.
But does the point I'm making is I accept that the 20% recognition rate triggers certain consequences, but am I right in thinking that it has to be part of the border procedure before that actually kicks in?
No, if I understand correctly, if you if you are from a country with a 20% recognition rate, then you move into that accelerated procedure.
I see. Could I ask Mr. Leonard if he would, just in relation to the A and B case and the I don't know whether you were involved in it personally, but well, then you can speak more freely about it, I suppose. In relation to that case, it seems to me that a lot of Miss Justice Phelan's findings went far beyond the mere non-compliance with EU safe country criteria by the Minister's original determination, and that there are other issues that she parked, so to speak. Are they going to come back and bite us? And have you any insight into the capacity of the Oireachtas to deal with the kind of a menu of items which are hovering there in her judgment but not decided?
I would think the Department of Justice will probably be looking at those aspects of the judgment which raised issues that could come up again, and the Department will probably look into whether those items can be addressed before they will raise their head again in more cases. So
it's not just a simple technical bill of tweaking one little thing. If we're going to deal with all of the issues raised in the judgment, there's going to be a lot of legislation involved, do you think?
Well, one of the issues that was there for potential determination was whether there was a lawful basis for data sharing between Ireland and the UK.
Yeah.
I mean, that's obviously not covered by anything to do with the EU Migration and Asylum Pact, but it's something that the Department might want to consider, and I'm sure they are considering.
And will Rwanda disappear as an issue, in your view?
Well, I mean, who knows what is going to actually happen. I know that the UK have passed an act that says it's lawful to send people to Rwanda, but I mean, we're in unprecedented territory as far as I'm aware, because that act was passed to get around a judgment of the UK Supreme Court. It wouldn't be a lawful act if it was passed by the Oireachtas over here because of our constitution, but it's interesting to see what will happen over there because they don't have a written constitution and they place a lot of weight on parliamentary sovereignty. But I'd be slow to predict that Rwanda will actually go ahead.
But if it does go ahead, if they do start deporting people to Rwanda, are our courts going to say, hold it, we will not deport people to the UK as a safe country?
Well, given that the UK Supreme Court has said the previous proposal to send people to Rwanda was unlawful because it could lead to a breach of human rights, applicants, if they're at risk of being sent to the UK and sent in a chain then on a flight to Rwanda from the UK, they would argue that Ireland couldn't lawfully send them to the UK to expose them to that risk. So there would definitely be case law on that if Rwanda does go ahead and people are at risk of that through being sent from here to the UK.
Thank you.
Thank you.
Okay, thank you. I'm going to call the next member now, who's Senator McDougall.
Thank you, Chairman. Can we just go back to the issue of whether the border procedures apply to somebody who has been in this state for some time? And if they, I'd just like clarity on that, because looking at the briefing paper that we got from the Library and Research Centre on the 20th of December 2023 concerning the Pact, The core aim of the proposed screening regulation is to strengthen control of persons at external borders. It will apply to persons entering the EU territory without fulfilling the entry conditions, including individuals who request international protection at an external border crossing point or in a transit zone, individuals who are brought ashore following a search or rescue operation at sea, individuals who are apprehended in connection with an unauthorised crossing of an external border by land, sea and air, and individuals who are apprehended within the territory of an EU member state who eluded controls at the external borders at first instance. Is somebody who's been in the state for some time, if I could ask the Department of Justice, is somebody who's been in the state for some time within the ambit of the border procedures, the external border procedures and the screening process that follows from that?
Just to say firstly, Senator, thanks for the question. The screening regulation obviously is a Schengen measure, and Ireland won't be opting into that, but it is the intention for us to replicate the provisions of the screening regulation insofar as possible if a decision is taken to opt in. The screening regulation does apply to people who are found to be irregularly staying in the territory of the member state, and a screening procedure can take place at that point. In terms of the application of the border procedures, our interpretation is that an individual should be apprehended crossing a border point, and that if it's a case that they, for example, show up at the International Protection Office, that we have not actually apprehended them crossing a border, and as such the border procedures won't apply. Now this could be subject to change. For example, it is open to us to designate other locations in the territory as a port of entry. So, for example, if we identified that the effectiveness of the border procedure wasn't what it should be, we could designate other points in the state as ports of entry for the purposes of the border procedure.
But will that be a matter of Irish law or EU law? Was this sort of an additional thing that we can do, or
it would be a matter of Irish law.
Yes, so it's an optional thing for legislation, is that it?
There is legislative provision already in place for that.
And just in relation to the legislation that the Minister has brought to Cabinet today and has got authority to draft or whatever, or to proceed with, first of all, does that legislation deal with the Rwanda question? In other words, does it deal with the scenario that somebody who comes through the process in Ireland, and eventually we want to send them back to the UK, can make the point, sorry, I'm not going back, because the Rwanda policy has been found by the European Court of Human Rights to be in breach of the convention. And is that going to remain a serious issue from our point of view unless and until the UK government abandons Rwanda?
Essentially, the legislation that Cabinet gave approval to draft today will address some of the procedural safeguards that the High Court deemed were missing from the legislation.
Yeah, I know the procedural ones, but this Rwanda question...
And just to say, yeah. Senator, the High Court didn't make any finding in terms of the safety of the UK or otherwise. Obviously, the legislative changes are necessary to enable the designation of the UK as a safe third country, again, once the legislation is enacted. And it is the Department's intention to continue to operate returns to the UK under the agreement that was agreed in 2020 following the UK's exit from the EU.
I follow that that's the Department's intention, but I mean, as I understand both ECHR law and the court decisions until now by English courts, the Supreme Court in England, the use of Rwanda is considered unlawful under international law. And I'm asking the very simple question, is a lot of this academic? Because people will actually be able to say to the Irish courts, excuse me, you may have remedied what Miss Justice Phelan found as technical defects, but I have a fundamental objection to being sent back to the UK, that I'm exposed to a risk of going to Rwanda. And I just wonder, where we are on that.
I've just, I suppose, two things to say about that, Senator. Firstly, the legislative fix is not simply to deal with the UK. The option is there for just the Minister to designate other countries as safe countries, and that needs to be remedied.
But 80% of asylum seekers, we were told, were coming from the UK. So I'm just wondering, are we talking about something which is going to come unstuck because 80% of asylum seekers are going to be able to say, sorry, I object to being sent back to the UK as long as the Rwanda law remains in position? And will the Irish courts?
I think it's an interesting point, Senator, but I think Ms Kenny was about to elaborate further.
Sorry, I was. Thank you, Chair. Just to say, obviously, we can't predict what a future court will determine. Of course, it's open to an applicant to make an argument such as what you've outlined. Obviously, the UK policy has not been operationalised as of yet, and there's been no actual ruling from the European Court on it. So I think that's relatively premature at this stage.
Okay, thank you. I'm going to move to the next. Very good. Okay. Did you want to make a comment? Yes, Mr. Bruton? Yeah.
Just a very quick comment in relation to the first point, which was around extending the screening to people in country. Just to put on record that MRCI would have deep concerns around that, around ethnic profiling, apprehension, detention, and a denial of due process that currently exists for people who are found in country who may be undocumented or otherwise.
And sorry, Mr. Bear with me, just those remarks were made in the context of the Rwanda policy?
No, the Senator's previous question about the screening, whether that could be extended to people in country. No, the screening procedures. Okay. Sorry, okay, very good, okay. I'm just trying to keep that, there's multiple topics being debated today, and when we go to look at the transcript and so on and so forth, and people, review the comments of the committee, I want to make sure that it's clear what every contribution was directed towards us so that it helps illustrate points being made. Thank you.